Okay, good afternoon. I am so excited to be giving you this presentation today. My name is Jacqueline Robertson. I am an attorney here in San Antonio, Texas. I have a law firm, Robertson Duran Law, which I run with my partner, Laura Duran. At our firm, we handle family law, estate planning, and probate. And I would like to thank Texas Legal for inviting me today to present on estate planning. And why I think it's so important is, you want to prepare and protect your family. And estate planning is a great way to do that. Unfortunately, I will say within the past year and a half, we have had a lot of people contacting our office because they have lost loved ones, and it was unexpected, it was sudden, and there were no safeguards in place. And so that's why, we really recommend that people get their estate planning done, because it's something that's so ultimately so simple, so quick, so easy for most people, and it helps to alleviate problems for your loved ones when you pass away. So, so just a little bit about me. Like I said, I am here practicing in San Antonio, Texas. I am a San Antonio native, and I attended UT for undergrad and Tulane for law school. And as I stated, I focus my energies in family and estate planning. So a lot of people don't realize they have an estate. You think about estate and you think about the sprawling mansion and lots of money. That's not necessarily what an estate is. An estate is simply everything that you own. So you could have an estate that includes real estate, and that could be your home. It could be property that you own. It can be your bank accounts, your retirement accounts, investment accounts, and then also personal property. So that could include jewelry. It could include, maybe you have an extensive instrument collection, or maybe you have an extensive video game collection that is very valuable. That's all part of your estate. And so when we talk about estate planning, that is essentially making a plan in advance to handle your affairs, not only when you pass away, but during your lifetime. A lot of people think, well, I just need to have a will. And you don't just need to have a will. Really and truly, you're only going to use a will once in your life. But as far as like other estate planning documents, you will need those throughout the course of your life, and I'll certainly get into those. I think everyone needs an estate plan. We've done estate plans for people in their early 20s, and we've done estate plans for people in their later stages of life, 80s and 90s. It's never too late to do one, and the benefit to your family is so significant. When we talk about the purpose of estate planning, why is it necessary? What I always like to point out to people is it just makes your loved ones' lives so much easier. So for example, if you have a will and it is a properly executed and valid will, all it takes in Texas is for your named executor to hire a lawyer, and that lawyer will prepare the documents, file them with the court, and in Bexar County, at least, in 2 to 3 weeks, you can have a hearing. And depending on the court, you may not even have to have the hearing. And everything is signed, and now you have the power to act as executor, and you can start to distribute assets. Everything can be handled in a matter of a few months. If you don't have a will, then it can require a very lengthy process. First off, it's going to require hiring an attorney to help your loved ones figure out exactly how to handle your estate, because they will not know. They will have no instruction. And they could either find that they can do some very simple documentation that gets filed with deed records, or a very complicated multi-pronged process that requires several years of litigation. And not to mention that the court won't know who your heirs are. In Texas, you can disinherit whoever you want. You can give a gift in your will to whoever you want. There's no restrictions or requirements. So we see people who will sometimes provide more for like maybe a younger child or a child who has special needs, or a child who maybe just won't be able to care for themselves the way the older children will, and that's perfectly okay. When you don't have a will, the court has to just figure out who your beneficiaries could be under Texas law and then distribute accordingly. And so your assets may be distributed in a way that you didn't want or anticipate. Now, also when we talk about estate planning, again, it's not just about when you pass away. So, and you can accomplish estate planning in a multitude of ways. So you can look at lifetime gift giving, and that's especially relevant if you have a larger estate and you're trying to help avoid certain taxes. Joint ownership. Sometimes what people will do is they will say, hey, I'm going to have a bank account, but it's going to be a joint bank account. And that way, when one party passes away, the other party is able to have access to the money immediately to help not only themselves, but to also help take care of the estate's affairs. You can also prepare trusts, which we will get into a little bit later. You can prepare your last will and testament, and then also powers of attorney. And so we'll get into what those different documents are in a little bit here. So your last will and testament, that is what determines how your estate is distributed. So in that document, that's where you name your executor. If you have minor children, that's where you state who you want to be your children's guardians. That's also where you name your beneficiaries. Your beneficiaries are the people who are going to inherit under your will. That's also where you're going to state how your assets are distributed, and you can also use it to state how you want your remains to be disposed of. If you want to be cremated, if you want to have a specific kind of event surrounding your burial, you can specify all of that in your will. When we look at executors, for example, you want to make sure that you pick someone who is trustworthy and will carry out your wishes and will do so in a timely fashion. So your executor, as stated, it should be someone you trust. It should be someone who can handle your affairs. You also want to make sure that they're able to serve under the law. So, for example, you need to pick someone who their criminal background is clear, because that is certainly a factor under the law that could prevent them from being able to serve. And also just thinking about your family and your friends, who's the best person to really make sure that your wishes are known. A guardian. So in your will, or even in a separate document, you can designate who you want to be your guardian. In Texas, a guardian is not what people call them in other states. Here in Texas, a guardian is someone who can manage either your person or your estate, meaning that this is someone who is appointed by the probate court to handle your affairs and to also look after your physical body when you're incapacitated or not able to do so. Also, what we see a lot in estates is, let's say a parent passes away, they have a life insurance policy and they left that life insurance policy to the children. Most life insurance companies will not let those children even receive that money unless a guardian is appointed. And that does not mean that because you're the surviving parent that you automatically step in and are able to get that money for them. You have to be appointed a guardian by the court. It can tend to be a kind of tricky and hard to understand process. And so one thing you want to do is, when you are meeting with your estate planning lawyer, you want to talk about, well, I have life insurance and I have minor children. What should I do here? Requirements for your valid will. Of course, you want your testator to be older than 18, so 18 and up. You want to have 2 impartial witnesses. What we do typically at our office is we have our employees stand in. That way you're picking people who don't know you, and so there's no question as to whether or not there is any kind of coercion or fraud or anything going on as far as the witnesses. You must be able to sign a will. So when we say testamentary capacity, you must be able to be of sound mind and actually be able to not only communicate what you want in terms of your will and your assets, You have to be able to sign in some kind of way. A lot of times people might be at a point where they can't sign very well. That's fine as long as they can sign and they can understand what they're doing and what a will means for them. No undue influence. So you always want to be careful when either someone is getting a will signed or maybe you are the one signing a will, that you're not being forced by anybody to do it. And good estate planning attorneys, they will interview you. They'll talk to you, some of your family that you designate, to make sure that this is your decision and not something that somebody else is making you do. Wills also in Texas must be in writing, signed, and dated. So that's how we make sure that our wills are valid and that a court's going to accept them. So next we'll talk about trust. And so a trust is essentially an entity that's created to hold your property for your benefit or for your beneficiary's benefit. People like to create trusts, especially if they have maybe either a larger estate or they want to avoid some of the aspects of probate, or they don't want there to be any confusion when they pass, and so things can be passed on and inherited pretty quickly. So you have your grantor. So that's the person who is passing on legal title to property. So that would generally, if you're the one preparing a trust, that would be you, the person creating the trust. The trustee is someone that you designate who will manage the assets that are in the trust. And that can be, depending on when you create the trust, that could be yourself, it can be family members, it can be professionals who are designed to manage trusts. I have seen some great professionals at banks and different entities who have actually managed trusts so well that they've increased the value tremendously for the benefit of the beneficiaries. With a trustee, you always want to pick someone you can trust, because you don't want someone who is going to somehow figure out how to deplete assets or mismanage the trust or bring harm to the beneficiaries in any kind of way. And then the beneficiaries are the people who benefit from the trust. So that can be you, that can be family members, it can be charities. Those are the people who actually are going to receive benefits and assets from the trust. And so, like I mentioned before, some people will ask, well, why should I have a trust if you have a sizable amount of assets, but maybe you want to manage how those are distributed? You can do things like designate, well, I have this trust, I want my child to receive these funds, but not until they finish college or not until they hit 25 or 30. You can certainly do that. And you can even do that within a last will and testament. And so if you pass away and somebody maybe is under an age that you think that they're not very responsible yet, you can specify, okay, I want them to be able to access this trust at a later age. And you can also put in terms for how you want that trust to be managed. If you have an heir or beneficiary who maybe is disabled and might need some kind of assistance, you can also create a trust that will address that as well. Or if you want to avoid estate taxes and gift taxes. And so, one thing that we tell people is, again, when it comes to the value of your estate, it doesn't have to just be a sizable estate that qualifies for a trust. You can certainly have a smaller estate and seek out a trust. It's all about what your needs are, and that's definitely something to speak with your attorney about. With your trust, like we talked about, you can put conditions on the assets. You can protect those assets from creditors. You can avoid, for the most part, the probate process. Trusts are more private. In Texas, your will, the whole probate process generally is public record because everything gets filed with the court and people can go and access it. Trusts do tend to be more complex, so that is a downside. And they do tend to be more expensive and take more time to prepare. So sometimes, we'll have people and they'll call our office and they'll say, well, I'm about to go traveling and I'd like to have a will done in the next, week. That's fairly easy, especially if they're seeking a simple will. That's fairly easy to accomplish. If you're looking for trust, you need much more time than that, because you want to make sure it's prepared correctly with your wishes in mind, and that the attorney preparing the trust has all the information they need. And then we always remind people, you have to fund the trust. You can create this entity, but if you don't actually fund it, meaning assign assets to it, then the trust is just empty and it doesn't mean anything. And then we also counsel people on the kinds of property and items they should and should not put in the trust. Revocable versus irrevocable trust. A revocable trust is in the name. It can be changed at any time. It can be revoked, and they're considered your personal assets. So there's no necessarily protection there. Not the way that you might think of with a trust. With an irrevocable trust, once it's created, it can't be changed. It can help you to reduce estate taxes and protect your assets. And it can help if you are needing it for later Medicaid planning and obtaining government benefits. And that's crucial for people who might find themselves ultimately going into a nursing home or some kind of long-term care facility. A special needs trust is a trust that's established for beneficiaries who are disabled or otherwise need help with their own care. And so you can create a trust that would manage those assets and benefit that beneficiary. And then a pour over will, that's something that's like a catch-all. So what we tell people is when you request a trust, you still do need to prepare a will. For the reason I mentioned before, sometimes people forget to fund a trust, or they forget to move certain assets into a trust. Maybe they forgot they had something, an account or property. And then, if they pass away and there's no will, now what do we do with these assets that weren't part of the trust? So it's still necessary, but certainly you have a lot of protection there with the trust. So when we talk about incapacity planning, this is something that I'm very passionate about with my clients, because a lot of people just don't understand what that really means. And so incapacity planning is essentially making sure that if something happens to you while you're alive, that you are protected, that your assets are protected. So you're protected both medically and financially, as well as your wishes are understood. And so there are a number of different documents that we do recommend that people obtain during their lifetime. So, for example, a power of attorney, first off, a medical one will allow who you designate to make medical decisions on your behalf, be able to communicate with medical personnel. And that's very important, because if you're incapacitated, let's say, unfortunately, you end up in a car accident, or you are in a very lengthy surgery and you're not able to make certain decisions for yourself, that person can step in and be able to do that for you, following, of course, the wishes that are placed in the medical power of attorney. We strongly recommend you pick someone who you trust, because this person could theoretically have your life in their hands. So be very mindful of who you're designating as your power of attorney. Same goes with what we call in Texas a durable power of attorney that manages your financial affairs. The good thing about durable power of attorneys in powers of attorney in Texas is that you can be as specific or as broad as you want. You can give that person all the rights in the world, or you can say you only have the right to do these little things here. And that person can certainly help you if, again, you're incapacitated. Let's say you find yourself in the hospital unable to make your decisions for yourself. This person can step in and make sure your bills are paid, maybe making sure that they're able to access money to take care of some of your affairs. And again, picking someone you absolutely trust, because you don't want someone who's going to deplete your assets and run. And so having those powers of attorney can definitely give you peace of mind. Also, a very big benefit to having powers of attorney is if you find yourself incapacitated and you may not recover, you may always be incapacitated, it can certainly help prevent the cost of getting a guardianship, which is a much more costly and lengthy and time consuming process. And so, if you're able to get a power of attorney before that happens, it can greatly minimize the stress of having your loved ones go and seek a guardianship. And also, going into guardianship, if someone's awarded a guardianship over you, either over your person, your physical body, or your estate, then you lose those rights. Those rights go to someone else. Powers of attorney can always be revoked, but with a guardianship, you can't do anything about it. Once it's there until a court says otherwise. And so, really thinking smart and getting those powers of attorney done now can be so important. And they're such short documents. When you see them, you think, that's it? That's all I needed to do? Versus a guardianship, you could be pending in court for a couple of years before you finally get in front of a judge. Maybe it became contested and there's a lot of fight. Maybe there's delays, like we've seen a lot of delays, unfortunately, because of the pandemic. And so having a power of attorney can help people help you now and quickly. I went over medical and durable power of attorneys. Now, another thing would be a HIPAA authorization, or we call them HIPAA releases. That basically allows you to, give someone else the right to receive information about your care. So maybe you have loved ones who you want them to be able to communicate with medical staff and about your care. You can sign a HIPAA release. Sometimes hospitals will have them already, or you can always have your lawyer prepare that for you. But either way, that is definitely something that we find to be very important. Advance directive. This is also something that is so crucial. I'm sure some of you remember stories in the news, especially when we were growing up, about people who found themselves in comas or persistent vegetative states, and they weren't able to make any decisions for themselves. They couldn't communicate, and they were left on life support for years or even decades. With an advance directive, it allows you to make those decisions before that time ever comes, if it ever comes. And so it's an end of life decision. And what's good about an advance directive, which you may also hear referred to as a physician's directive, or some people call it a living will, what's good about that is that it takes the decision making out of your loved one's hands. Because for some people, if they get to that point where maybe they're incapacitated, they need to be on life support, and life support's the only thing that's going to keep them alive. Asking your loved ones to make that decision can be so difficult. And unfortunately, we've seen it happen so much in the past couple of years. And we've had so many people call our office trying to, at the last minute, get powers of attorney for their loved ones. And we ask them, well, where's your loved one? What is their capacity level? And they tell us, well, they've been in a coma for 2 weeks. And we have to tell them there's nothing that you can do at this point. They can't sign anything. They're not capacitated. So getting something done now will allow you to have peace of mind if something happens to you down the road. You can designate that you want to be on life support, or you can say, no, I don't want to be on life support. And actually at our office, in our advanced directives, we do put in for some people a clause that says that they want life-sustaining treatment if they end up diagnosed with COVID-19. And so, you can be specific like that in your advanced directive. All right, well, that is the end of my presentation on estate planning. I hope y'all thoroughly enjoyed that. I do see that I have some questions, so I'll go ahead and answer those for people. If you have any other questions, you can certainly put them in the chat if you're watching on Facebook or YouTube. One question is, how often should our will be checked to make sure it is up to date and okay? So what I like to tell people is definitely update your will anytime there's a life-changing event. And so life-changing event can be marriage, divorce. It can be the death of one of your beneficiaries, close relatives, so siblings, spouse, brother, sister, parent, but always, updating after any of those events occur. If you adopt a child, for sure, updating your will. And then also I would recommend, every few years, just looking at your will, having a lawyer review it. In Texas, the estates code likes to change on us often. So what the requirements for a will would be in one period might change a little bit in another legislative session. So I would say, even if you don't have a life-changing event, every few years, just asking a lawyer, hey, can you look at this and tell me if this is good? Do I need to make any changes to it? The good thing too is if you spend a lot of time on your will, creating it, you spend a lot of money on it, and you have one small change or addition, that can also be achieved through what we call a codicil, which is just a simple addition to your will. It can even just be a one-pager. What we tell people is once you have a will prepared by a lawyer, notarized, executed, and it's safe and sound somewhere in your home or maybe in a safe deposit box or something, do not ever make your own changes to it. Do not write on it. Do not remove pages. If you want to make any change to your will, you contact your lawyer and you say, I need to make some additions, and let them do it, because they will do it in a way that will not invalidate your will. Next question is there a way to complete a probate before death or pay for it in advance? So with probate, you can't really probate someone's estate before they pass away. However, paying for it in advance, sure, there's different ways that you could address that. You could address that through a trust. You could set up something. Some people, have lifelong attorneys. They have a relationship with their attorney for decades. You can always set up something with them and say, I want to leave money for you in retainer so that, when I pass away, my relatives don't have to worry about this money. They can just use this money to go ahead and probate my estate. So there are ways to set it up, but otherwise, no, you cannot probate someone's estate before they pass away. Can a trustee also be a beneficiary? That is a great question. I generally would not recommend that. You can certainly, there are times when you create your own trust and you are the beneficiary of that trust. But I think it's smart to keep those separate. Can my will leave all of my assets to a family trust? So that question kind of tells me that what they're asking is, once I prepare my will and once my will is probated, then can those assets be put into some kind of family trust? So you can create a trust upon death. You can create a testamentary trust. You can also create a contingent trust, which is one of those trusts that's created if somebody passes away and certain conditions are met. You can certainly do that. Another question, how to get copies of an already filed estate plan if lost? So and I will tell you, that's definitely one reason to hire an attorney to do your estate planning, because what they should do is store copies of your estate plan with their office. However they choose to do that. I know some lawyers who literally have like a room full of like fireproof filing cabinets where they've got everybody's estate plan saved. Other people who have servers who save it in the cloud or however they save it. You definitely want someone who has copies, and you want to make sure that your loved ones and everyone, relatives, know who the attorney was who prepared your estate plan so they can contact them in case anything happens. If you do lose something, like you lose your will, you lose the power of attorney or what have you, if you have those things on file with a lawyer's office, you can at least contact the lawyer's office, get those copies. If something happens to your will and it's destroyed, that does not mean that a copy can't be probated at court. It just means it's going to be a little more difficult, a little more time consuming, but it's certainly not impossible, and people do it all the time. I would recommend, to avoid losing those estate plans, what I would strongly recommend is having some kind of secured system, whether that be you're putting it in a safe deposit box, you're putting it in a safe somewhere that's safe and where people know how to get to it. With a safe deposit box, you do have to be careful, because if you leave it in a safe deposit box and let's say you pass away and your executor is not also named on that safe deposit box, then we have to file a motion to basically have the court approve the bank to go in and open that safe deposit box. It's not impossible. I've done it plenty of times, but it is a lot easier if we don't have to do that. So, but if the safe deposit box is your only place of saving something, perhaps consider making your executor one of the holders of that safe deposit box. That way, when the time comes, they can have access without having to go to court. I'm looking for any other questions here. All right. Well, I don't see any other questions, and I so appreciate everyone for tuning in. I hope that I was informative and helpful to you. There's my contact information there if you have any other questions and would like to reach out. And thank you again to Texas Legal for this opportunity. Take care, everyone.